The Supreme Court has struck out earlier judgments of the Court of Appeal, which directed parties in the African Democratic Congress crisis to maintain status quo ante bellum. The Apex Court held that since there was no outstanding case before the Appellate Court, it lacked the jurisdiction to make a declaration that gave the impression that the parties had issues before the Appeal Court, which needed to be resolved and which could suffer if the situation was not maintained the way it was. The Supreme Court described the position of the Appeal Court as unnecessary and unwarranted. The ruling had formed the basis for the decision by the Independent National Electoral Commission to remove the names of David Mark-led executive of the ADC from its official portal.
The order made by the Court of Appeal that status quo ante bellum be restored had been set aside. In other words, the basis upon which INEC acted to remove the name of Senator Mark and his escort had been removed by the Supreme Court, agreed that the order of status quo ante bellum made by the Court of Appeal was unwarranted and no basis to make it was unnecessary.
Out of 7 grounds of appeal, 6 failed. They filed 7 grounds of appeal. Grounds 1 to 6 were a complete failure. Supreme Court dismissed them. The ground 7 that succeeded is limited to the narrow issue of the consequential order. Status quo ante bellum. Should the Court of Appeal have made that order? Supreme Court said no. That the only court that can make such an order is the court that still has case pending before it, which is the federal court. So that is the only narrow issue in this case. It failed on every other ground.
Counsel to David Mark, Jubril Okotepa, described the judgment as a victory, insisting that the Supreme Court decision validates his client's position and allows his leadership to continue party activities pending further proceedings.
The Supreme Court allowed the appeal. The objection to the competence of the appeal was dismissed. The appeal was valid, but they agreed that we ought not to have come to the Court of Appeal for the question to come and show cause. And so we're going back to the Court of Appeal.
We have repeatedly maintained that anything contrary to what the Supreme Court has ruled will have set Nigeria's democracy back by many years. So we are glad we have remained confident in the judiciary. We have repeatedly maintained that we are confident in the judiciary, and we are very proud as Nigerian citizens today that the Supreme Court has not let the judiciary down, has not let Nigeria down, and as Nigerians we are very proud. And this means to us that democracy will survive in Nigeria. Then we can go back and begin to do the hard work.
However, counsel to Naifu Bala Gombe, Robert Omuperu, offered a contrasting interpretation, stating that the Supreme Court did not determine who the legitimate party leadership is. He noted that out of 7 grounds of appeal, only 1 succeeded, the issue of jurisdiction, while the core leadership dispute remains unresolved.
The Supreme Court did not enter into such an issue to decide whether this person is the chairman, whether this person, that issue didn't come up at all. It fell within a very narrow technical compass. Was the Court of Appeal right to decline to hear their appeal? That's all. And Supreme Court said, yes, they were right, but they were wrong to have made out that for status quo.
The Supreme Court has directed all parties to return to the Federal High Court, where the substantive matter is pending for accelerated hearing and final determination. Legal analysts say the ruling leaves both factions claiming partial victory, while the real battle returns to the trial court, where the issue of jurisdiction in matters of internal party dispute will be a major issue in contention.
Of this appeal was to get the Supreme Court to decide the issue of whether or not the claim before the Federal High Court was justiciable. Was it a justiciable claim or was it not? Supreme Court said the Court of Appeal properly declined to hear it because that issue is properly before the Federal High Court. We are going back to the Federal High Court for the case to be heard on the merits, on the basis of the order of the Court of Appeal for accelerated hearing. Let me make the point. The order for accelerated hearing made by the Court of Appeal was not a subject matter of appeal So nobody challenged that order. So that order is still subsisting.
With no definitive pronouncement on who leads the ADC, the leadership crisis remains far from over, even as political alignments ahead of 2027 continue to hang in the balance. In Abuja, Chimize Nzadima reporting for Signature Television.